Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? Court will sentence you to 2 years in the prison, give you credit for any time served. There's an affirmative finding of a deadly weapon. Court is calling 2022 CR 11874, State of Texas versus JC Laday. Can I have parties announced for the record for the state?
Brittany Mitchell for the state.
Defense?
Orlando Way for the defense.
Are you Mr. Laday?
Yes, ma'am.
Counsel, have you received all the discovery and did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Laday, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented? All right, Mr. Laday, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Counsel, did you understand what you're charged with is aggravated assault with a deadly weapon?
Yes, ma'am. Yes, ma'am.
Uh,
Wait a second.
Yes. The range of punishment for that offense is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Laday, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Has anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial.
Yes, ma'am.
Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 2 years in the prison. There's an affirmative finding of deadly weapon, no applications, and an affirmative finding of family violence. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, ma'am.
Did you understand that to be the entirety of your plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes.
Showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Yes.
State any evidence?
We have for state's exhibit number 1 or attachments.
Any objection?
No objections. To this.
All right, state, you may be excused to continue to confer. Mr. Laday, not you.
Sorry.
Mr. Laday, I'm showing you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Just that you follow the plea bargain agreement. Your Honor.
All right. Court will sentence you to 2 years in the prison. Give you credit for any time served. There's an affirmative finding of a deadly weapon. And there's an affirmative finding of family violence. Is there anything else from either side with regards to sentencing?
Nothing further from the defense.
All right. And I am sorry, let me see. I am going to do a no contact order. And I know that wasn't requested.
Your Honor,
Your Honor,
the witness is deceased.
No, there are other people
yeah,
in the
with
household.
With the roommate, yes.
Yes. So is there going to be any objection to the court adding to the plea that he's to have no contact with Angel Vasquez, Sarah Espinoza?
Try a quick moment.
Yes. And Nathaniel Zermino.
No objections. Though.
All right. So the court is going to order also no contact with the following persons. Nathaniel Zermino, Zermeno. Sarah, Sara, Tiffany with an I. Espinoza with a Z. And Angel Vasquez. All right, Mr. Laday, showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? Because this is an affirmative finding of family violence, and also because this is a conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. How old are you?
23.
All right, you're 23 years old. You're going to have to start changing your life. If there's a drug or alcohol problem going on with you, you need to make sure that you take care of that, because otherwise you're going to be in and out of prison and in and out of court system. You understand?
Yes, ma'am.
All right, good luck to you. Thank you, counsel.
The atmosphere in Judge Stephanie Boyd's courtroom was standard for a plea hearing: procedural, quiet, and seemingly routine. J.C. Laday, just 23 years old, stood before her, having agreed to a deal with the state of Texas for the charge of aggravated assault with a deadly weapon. The charge carried a serious enhancement, an affirmative finding of family violence. This single detail meant Laday was surrendering his right to own a firearm and his ability to be a primary custodial parent. It was a heavy price, but one he accepted as part of his bargain for a 2-year prison sentence. Judge Boyd meticulously walked Laday through the standard admonishments, ensuring his plea was knowing and voluntary. He confirmed he understood his rights, the charges, and the consequences. He pleaded guilty. The court accepted the evidence, found him guilty, and was prepared to follow the plea bargain to the letter. 2 years in prison, credit for time served. Is there anything else from either side with regards to sentencing? She asked. Both the state and the defense replied, no. But then, the courtroom drama escalated. Judge Boyd paused, looking down at her papers. I am going to do a no-contact order, she stated, her voice firm and resolute. And I know that wasn't requested. The shift in the room was palpable. The defense attorney immediately tried to interject, but Judge Boyd was already listing the names: Nathaniel Zermino, Sarah Espinoza, and Angel Vasquez. With a deadly serious tone, she legally barred Laday from contacting these 3 individuals, a powerful condition that was never part of the original negotiation. It was a move that destroyed the expectation of a clean deal, asserting her authority to protect the victims and witnesses involved. As the hearing concluded, Judge Boyd wasn't finished. She looked directly at the young man, her expression shifting from judicial authority to something resembling stern disappointment. How old are you? You're 23 years old, she said. You're going to have to start changing your life. If there's a drug or alcohol problem going on with you, you need to make sure that you take care of that, because otherwise you're going to be in and out of prison and in and out of court system. You understand? With those final, poignant words of warning, she wished him luck and moved on to the next case, leaving behind a powerful reminder that a judge's final decision can carry more weight than any signed piece of paper.